I have not something that's
On the record in the matter of the state of Michigan versus Mark Anderson, 5-02492 appearance, please.
Thank you, Your Honor. Cassidy Kachukas for people appearing or permission to practice pursuant to MCR 8.120 with Jen Lawson as my supervising attorney.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Mark Anderson, who appears today via public counsel in the Ingham County Jail.
Okay, today was the date that was set originally for a preliminary examination. The court did find good cause to adjourn the timeline with the understanding that there would be a competency evaluation needed. The court's not received any paperwork.
Yes, Judge, I did. I thought that had been, it's my fault, to be clear. I thought it had been already filed earlier this week. I did bring, it apparently was not. I did bring it today, if I may approach.
I think you have a copy of this complaint. Are you intending to attach that?
Oh, I intended to attach it in case the court wanted or needed it.
So, order for the defendant to undergo a competency evaluation has been signed, and the case will be set for internal review. See when we get our report, okay?
Thank you.
No problem. Any additional matters to the record?
Not you, Your Honor.
Not from the defense, just thank you.
Thank you. You can let them know you're all set in the jail, okay, sir? Thank you, Mr. Anderson. Let's see. That's Schuster. Who's representing Mr. Schuster? That's you as well?
I'm covering it today, Judge, yes.
Okay. This is the state of Michigan versus Adrian Schuster, 25-02219 appearance, please.
Your Honor, Cassidy Kachukas for people.
Good afternoon, or good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Schuster, who appears today via Polycom from the Ingham County Jail. I'm covering for his attorney of record, Eric Robinson, also.
Okay, I do have a pre-sentence report that was prepared on August 27th. You got a copy of that, counsel?
I do have a copy of it, Your Honor, just so the court knows I did meet with Mr. Schuster in a breakout room this morning and reviewed the PSI, so we're prepared to proceed.
Right, no need to make corrections, updates or deletions, or do we need to make some?
I do not have any corrections, Judge.
People do not have any either, Your Honor.
Thank you. You can make allocation.
Thank you, Your Honor. The recommendation from the pre-sentence investigation is that Mr. Schuster be sentenced to time served, that being 47 days. He's been in custody at the Ingham County Jail for that period of time, I believe since July 21st. Mr. Schuster, as indicated in the police report, or excuse me, in the PSI, Mr. Schuster is currently on parole with Michigan Department of Corrections. He is yet to face sanctions for that. The PSI is recommending time served in this matter because regardless of what happens in this case, he will remain under the custody and subject to sanctions by the Michigan Department of Corrections. It's unclear at this point what is going to happen, whether he be released on tether through them, whether he be returned to prison, or whether he be sent to something in between, that being a halfway house or some sort of rehabilitation. Mr. Schuster does acknowledge, as indicated in the pre-sentence report, he does acknowledge that substance abuse, and particularly methamphetamine, has been sort of the underlying driver of his criminal trouble. He's taken responsibility for both the case that he's before the court on and his ongoing substance abuse. And I think that the Department of Corrections is looking at taking action to further address some of that substance use. And so in that regard, Your Honor, we're asking the court follow the recommendation of PSI, sentence Mr. Schuster to time served, and allow the Department of Corrections to take whatever action that they're going to take.
Want to be heard at all?
Just briefly, Your Honor, I don't think that defense counsel or the PSI is inappropriate at this time. I do think it would be appropriate to simply just permit the parole board to handle this matter how they see fit.
The court agrees. The sentence of the court is credit time served. Best wishes to you, Mr. Schuster. You're all set.
Thank you.
You're welcome. The state of Michigan versus Mark Rubin, 25-02468, appearance, please.
Thank you, Your Honor. Cassidy Kachukis for the people.
Good morning, Your Honor. Christopher Wickman via Zoom this morning with Mr. Rubin sitting to my right.
Today was the date originally scheduled for preliminary examination. The court did indicate that we would treat today as a probable cause conference and waive the timeline as necessary. There was some additional discovery being sought. Counsel, did you get the discovery?
Good morning, Your Honor. I did not receive the discovery yet, but we have had some kind of updates in progress. I emailed with the Discovery Department last week extensively, and then Cassidy did follow up this morning with regards to the status of it. It looks like we are moving forward, but specifically the phone, which is kind of an important piece of this. It looks like that phone dump is maybe starting or in process. So we would ask for a later date for it to be set.
Your Honor, that is accurate. However, I do anticipate that the phone dump may take, it is a phone dump that is being investigated as if it may contain CSAM, and as such, it may take a couple months for that phone dump to come back, and I've communicated that to Mr. Wickman at this time.
So it sounds like it might be more than just a couple weeks before you can get the discovery you're seeking. Either way, this matter is going to have to be reset because we're not prepared to proceed today. And is your client willing to waive the timeline?
Yes, Your Honor, we've had that discussion today.
Mr. Rubin, you understand your right to have a preliminary examination within 21 days of the date that you were arraigned.
Yes, Your Honor.
And are you willing to waive that 21-day timeline so this matter can be reset, allowing your attorney to hopefully receive the discovery he's seeking to help prepare for your defense?
Yes, Your Honor.
Okay, is anyone threatening you to waive the timeline at all?
No, Your Honor.
November 14th. November 14th at 9:30 work for you, Mr. Wickman?
I'm sorry, Your Honor. Did you say November 14th?
November 14th, correct. That's a Friday.
I am currently scheduled to be in trial with Judge Kennedy on November 14th, Your Honor. That would be day 3, and I do expect it will go at least 3 days. If the court
November
is
20th.
November 20th, yes, Your Honor. What time?
9:30. At 9:30.
Thank you very much, Your Honor.
We'll probably see you in person November 20th at 9:30. Any additional matters for today's record?
Not for the people, Your Honor.
Your Honor, just on this one, I would just ask the court to take a look at the bond conditions. This is not a case involving firearms, alcohol, drugs, anything like that, medical marijuana, any of that. So I would just ask the court to, if the court would be willing to take a quick peruse over that. The allegations here are that my client supposedly met up with someone online in the middle of the day and things like that. So I think that those bond conditions are not rationally related. Just if the court wanted to review the bond conditions, I'd appreciate it. Thank you. And my client hasn't been in trouble in 20 years on anything, and it wasn't alcohol, drugs related before either, or firearms.
Okay, looks like standard conditions were imposed at the time of arraignment. Not to possess a firearm, ammunition, or weapon of any kind, no drugs or alcohol without a valid prescription, no travel outside the state without prior approval of the court. And the people want to respond.
Your Honor, those are our standard conditions for a reason. I mean, the no drugs that are not prescribed to you is basically don't commit a crime. I think it's appropriate to have the defendant remain in the state considering he was seeking to meet up with a minor. that he met over the internet. It was a chat sting case. That minor fortunately did not actually exist in the situation, but given that he was seeking to meet up with a minor, I think we should restrict maybe the area that he is traveling to still be within the state. And also defer to your discretion on that.
And just to clarify, Your Honor, we're not asking to waive this actual standard conditions that are non-optional, such as not leaving the state or anything like that. I just don't know that we need to ban alcohol, marijuana, or firearms when they aren't remotely relationally related to the case. Thank you.
Thank you. I don't see any reason to deviate from the standard in this particular case. These are very serious and concerning charges. And so the bond as set by the magistrate will continue. Any additional matters?
Not for the Your Honor.
No, Your Honor. Thank you for reviewing that.
No problem. Thank you.
Have a good day, everyone.
Same to you. On the record in the matter, is the jail here? This must be, is it Cheney, maybe? Okay, Ms. Donnelly's here with that one. Let's take care of that. On the record in the matter of the state of Michigan versus Brian Cheney, 25-00249, appearance, please.
Thank you, Your Honor. Can I speak to you for the people?
Good morning, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant Brian Cheney, who is appearing by video.
Thank you. Mr. Cheney was previously denied a public defender. It looked like he now has the office of the public defender.
Yes.
Okay, so today was the date scheduled for preliminary examination, but because he did not have an attorney, we elected to treat this as a PCC, and then my understanding is there is the potential for a competency referral.
Your Honor, I will, I met with Mr. Layton for the first time yesterday briefly, so I wanted to meet with him again after we're done here. If I could get a breakout room with him to go over a couple more things, and then I'll talk to him more next week.
Mr. Cheney?
Mr. Cheney.
Yeah.
Oh, you said Mr. Layton, that's just.
Oh, I'm sorry, that was my other client this morning. I apologize.
Mr.
Getting
Layton is-
confused.
Okay. All right, sounds good. So the court's going to find good cause at this point to go beyond the 21-day timeline due to the delay in appointment of the public defender's office, and then the potential for need for an evaluation. Now, you can log in and meet with your client, and then if you are going to proceed with the competency, you can let us know.
Okay.
Otherwise, we're going to go ahead and set this for another exam date, okay?
Yes.
September 18th at 9:30. September 18th at 9:30. You have any questions for the court today, Mr. Cheney?
No.
Okay, hang tight. Your attorney's gonna log in and meet with you.
Okay.
Thank you, Your Honor.
You're welcome. On the record in the matter of the state of Michigan versus Elijah Bailey Thomas, 25-02481, appearance, please.
Thank you, Your Honor. Can I speak to you for the people?
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Elijah Bailey Thomas, who is approaching up the table now.
As there's no Ms. Shamron Thornton here, the people are unable to proceed at this time, so I would expect a motion from the defense.
Thank you, Your Honor. At this time, the defense moves to dismiss for lack of probable cause.
Our motion is granted without prejudice. The people do have the right to reissue this against you. Do you understand that? Do you have any questions at this time?
No.
We'll get you a dismissal in just a moment, okay? And you're on GPS center? Okay, we'll notify them you need to go back down and have it removed. No problem. Now, this is the matter of the state of Michigan versus Shamron Thornton, 25-02486, appearances for the record.
Thank you, Your Honor. Cassie Chukas for the people.
Assistant Public Defender John Lee appearing on behalf of Shamron Thornton.
Okay, today was the date scheduled for preliminary examination. This is for assault with a dangerous weapon, police officer assault. There's also malicious destruction of fire or police property and a domestic violence. Are we running today?
Thank you, and I will defer to the defense if we are running. We have had discussions about how we be proceeding on this.
No, we are not running today.
How are we proceeding?
My understanding from my discussions with the prosecutor is that we will be waiving up on the two existing R&O and police destruction charges. Another charge will be added for attempted disarming. The assault with a dangerous weapon and a domestic violence will be dismissed.
That is accurate, Your Honor, and there will be preservation of the current offer, which is to plead to the counts of R&O and malicious destruction of property of police property.
Waiving on what again?
Waiving on the resisting and obstructing, on the malicious destruction of police property, and consenting to the added count of attempt disarming an officer. And I'm going to.
Waiving on count 1 and count 2
Yes,
and adding a count 5.
yes.
Attempted disarming a police officer.
Yes, the PAC code being 250.479B2, I believe A at the end for attempt.
And then dismiss count 3 and 4.
That is correct, Your Honor.
Ms. Thornton. You understand that you're being charged with felonies here?
I do.
You understand that you have the right, because they're felonies, to have a preliminary examination, and the purpose of the preliminary examination is for you to require the prosecutor to establish if they have sufficient probable cause that these felonies were actually committed, and then probable cause sufficient to charge you as the person who allegedly committed those felonies. You understand that? You want to waive your right to have that exam? Anyone promising you anything if you waive your exam?
No.
Is there any threats against you or coercion to get you to waive your exam? You're waiving it freely and voluntarily? Okay, you can have them sign.
Yes.
Your Honor, I realize I wrote down the counts in the wrong orders. I apologize.
I'm sorry?
I believe we spoke about the counts in the wrong orders. I believe count 1 was the FA that would have been dismissed. I apologize. I didn't catch that until just a second ago. I may have to.
I don't think count 1 is the other. I think the count 1 in my file might be assault. But
Okay. It's out of our usual order.
I told you. Oh.
Oh, it's out of order in the file as well. It's so count
It's just
2
don't worry
and
about
3.
this. Sign it out to here.
Sorry.
Anyways. Okay, so you're dismissing which counts?
Dismissing counts 1 and 4,
1 and 4.
counts 2 and 3, adding count 5.
One felonious assault being dismissed. Count 2 police officer we're keeping.
Yes.
Adding to count 5. I have that on here. malicious destruction of fire, dismissing,
Keeping.
you're keeping. Two, 3, and 5, pending dismissed. 1, 4 being domestic. violence. Bind over date's gonna be September 17th. That's the date the circuit court receives the file from the district court, not a day you need to appear in court, okay? Okay?
Yes, ma'am.
Your next court date's going to be a pre-trial in circuit court. Mr. Lee will be made aware of that date, okay? You stay in contact with him. Have an address for you ending in 2139, that's still accurate?
Yes, ma'am.
And I'm sorry, that was a phone number ending in 2139, and the address on Long Boulevard?
Yes.
Okay, it's your responsibility to update the court and your attorney with any changes to avoid you getting a bench warrant for failure to appear if for some reason you miss your court date or notice of a court date change. Do you have any questions at this time, ma'am?
No, Your Honor.
Your bond is 4,000 personal recognizance with GPS tether. That will continue as well as the no contact order. Any additional matters for the record?
Not from the people, Your Honor.
Only one other matter, Your Honor, in regard to the bond conditions, we would ask the court to consider the removal of the tether. This will good faith in making 2 appearances thus far in the case, and the assaultive charges have been dismissed.
Charges against that victim have been dismissed, so I will remove the GPS tether. You gotta go back down to county to get that removed, okay?
Thank you.
No problem. Do you have any other questions?
No, ma'am.
Okay, any additional matters, counsel?
Not from the people, Your Honor.
Nothing to the defense. Thank you.
And actually, I misspoke. I gotta get rid of the no contact. order.
Oh, that's right.
You're all set.
Thank you.
Is there anyone behind me? This phone is ringing. Do you want to be found in contempt today?
No.
Turn your phone off. Is Mr. Palmer here?
Yeah, he's right. I'm right. I'm sorry, I'm the one hiding.
No worries. State of Michigan versus Jonathan Watson, 25-02483. Appearance, please.
Thank you, Your Honor. Cassidy Kachuk, some people.
Good morning, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Jonathan Watson, who is not standing to my right.
Why is that?
Your Honor, I don't have an explanation for what Mr. Watson's failure to appear this morning. I will say that he did appear for the probable cause conference last week. I have had several telephone conversations with him recently as yesterday afternoon, about how we were going to proceed this morning. I did specifically remind him yesterday afternoon that he had a requirement to appear this morning in person at 8:30 for preliminary examination. I have also tried to call him this morning. I tried calling him about 9:15 this morning to find out where he was, I should say, and left a voicemail advising him that he was about 5 minutes away from the court issuing a bench warrant. I have not, as we stand here now, I have not heard back from him. I do not have any further explanation.
What's your bench warrant? Bond forfeiture. We could hold it for 48 hours.
Understood. Thank you, Judge.
No problem. Any additional matters?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
State of Michigan versus Shawn Williams, 25-01951. Appearance.
Morning, Your Honor, Jennifer Lawton on behalf of the people. Good morning, Your Honor. I need your LB for Mr. Williams, who is by my side.
That was the date that was scheduled for preliminary examination for criminal sexual conduct in the 2nd degree. Are we ready to proceed?
The people are ready. I believe that Ms. Wanji has a request for an adjournment.
Yes, Your Honor, I received as part of the discovery yesterday. We don't have the whole discovery yet. So I'm not prepared to, and I believe that these are substantial documentation that we need in order to prepare for the plea, especially also because the child is not going to testify. It's my understanding that they are receiving I received a notice where the prosecution wants to have the grandmother testify, and we want to answer that notice because we don't believe that all the conditions for the hearsay to be admitted are there. We also believe that the grandmother is the one who's putting the information child. I do not have the forensic interview of the child yet. I only know what they said that he said. And reviewing the CPS investigation, I have some concern about what the child has said because what we need to see, I need to see what was the interview, what the child said in the interview, because from what I have from the CPS, it is my understanding that the child disclosed that he's not afraid of my client. He doesn't know what my client did to him. Let me quote. The child indicated that my client was rude to him, which is why we kick him out.
You said he was rude to him, which is why what?
We kick him out.
Okay.
He described Shawn to be rude to him, as him scaring him all the time, but he was unable to describe how Shawn scared him. He's just, I just don't like Shawn for one reason. So we need to know what happened during the interview. What did the child say that the prosecutor will ask the court to allow the grandmother to corroborate what the child said?
Okay. My concern is I reset this all the way in July so that you can get additional discovery. Why have you not received it?
Can I respond to that, Your Honor?
Yes.
Couple of things. I was not present at the probable cause conference. There was another person from my office that was covering for me on that date. I had requested that a protective order be signed on that date for the forensic interview. I am unclear actually if that was signed at that time or not, but regardless, it did not make it into the file in my office. So that forensic interview was not sent because we did not have a protective order. During those entire 2 months.
Is this the protective order from July 24th that was signed?
Yes.
I signed a protective order in July.
And I don't know why my office didn't have that on record, but regardless, Ms. Wanji never reached out to my office regarding that until yesterday. At that time, I then sent over another protective order because I wasn't clear on whether or not we actually had one. I did receive that back from the court yesterday, and we informed Ms. Wanji that the forensic interview was done, ready to be picked up from our office yesterday. It is the people's intention, and I did file a notice regarding admitting evidence under MRE 803A. That is an exception to the hearsay rule that allows a victim who is under the age of 10 for the witness who was given the first disclosure to testify. That is the grandmother in this case. The grandmother can only testify to what the victim disclosed to her. She can't testify as to what was disclosed during that forensic interview. She wasn't there for that. So she can testify as to that first disclosure that was made to her. I do believe that that will be enough to satisfy probable cause in this matter. So I guess I'm unclear as to why the forensic interview is needed at this point to go forward on the exam as it stands today. However, I will leave that to the discretion of the court. I will admit that Ms. Wanji has not yet received the forensic interview.
Okay, so you're, at this point, we have witnesses here, but not the alleged victim?
Correct. The alleged victim is 5 years old. He is unable to testify based on information that I've received from his guardian as well as his therapist. However, his grandmother, who is also his guardian, was who the first disclosure was made to. She is present and prepared to testify today.
Okay, so the alleged victim's unable to testify at this time, or that's indefinite?
I don't know if that is indefinite or not. He is currently in therapy and going through receiving therapy as a result of this alleged incident.
That's not correct. This child has been in therapy since he has been adopted. This is a child who's been in therapy. Even the therapist said that he's been in therapy for months. So my client.
This is an adopted child. You said it was adopted when?
He was adopted, I think, in 2024.
Okay, and the entire time the child's been adopted, he was undergoing therapy?
It's my understanding that he's been going to therapy since that time. Okay. And so and also this is the thing, my parents and the grandmother are married and they're going through divorce. So it's our contention that this is part of that allegation about the child being molested. It's part of the grandmother being vindictive. And so we want to explore that.
I'm sorry, so wait, who's going through divorce?
The grandmother and my client.
The alleged grandmother and your client, you said?
Yes.
Oh, okay. Got it.
Well, that's something that they can cross-examine the grandmother about.
I need to be prepared to cross-examine the grandmother about that. I received the CPS report yesterday.
I understand. Receiving it yesterday probably falls on both of you for not staying on top of making sure the discovery was properly turned over. The court signed the order on the day of the hearing, which was July 24th, when the timeline was waived. I don't know why you didn't both get notice of that. Nonetheless, the timeline's already been waived. It's his right to have the speedy trial. He wants to delay it so that he can further gather information, and in light of the fact that we don't even have an alleged victim here, I have no problem with resetting this.
Thank you.
If the victim was here, I was not going to reset.
I understood, Your Honor. Thank you.
November 14th at 8:30. November 14th at 8:30 work.
Yes, Your Honor. Thank you.
That work for you, Ms. Wanji?
It does, Your Honor.
Oh, okay. Any additional matters for the record?
Nothing else from the people.
Nothing, Your Honor.
Thank you.
Thank you.
You're all set. On the record in the matter of the state of Michigan versus Anthony Goodall, 25-02487. Appearance, please.
Thank you, Your Honor. Cassie Chukas for the people.
Assistant Public Defender John Lee on behalf of Anthony Goodall.
Mr. Goodall has a examination for police officer assault. You running an exam today?
Your Honor,
Your Honor.
that is my understanding now.
What are we doing?
We're going to be entering a plea.
What is he on?
An offer has been extended at this time, Your Honor. It is that the defendant may plead to one count of attempt R&O under the understanding that the defendant will not seek HIDA.
He will not seek HIDA? He's not eligible, is that what you're saying?
Notice that he will not seek HIDA even if he is eligible, is part of the agreement.
Who would agree to that?
I'm sorry.
Who would agree to that?
Well, Your Honor, we understand that he already is on HIDA for something.
Is he eligible for HIDA was the question.
Oh, that's what you were saying, I'm sorry. I believe he is, yes.
Why in the world would he agree not to seek it?
Because he's getting the benefit of the misdemeanor.
Oh, okay. That's what he wants to do.
Your Honor, I appreciate it.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can put your hand down. This is an advice of rights and plea information sheet. It's 2 pages. This is the signature page. Is that your signature?
Yes.
You went over these rights with your attorney?
Yes.
Do you understand all the rights here?
Yes.
And you want to give all of these rights up?
Yes.
Do you have another matter pending? Before me?
The Jacob Raleigh case?
I'm asking, I'm only looking at the note. It says he's on probation before Judge Cole and bond for Judge Simmons.
Yes, he does have another matter pending before you. There are 2 cases. I'm looking right now at the charges. They are both for probation violations.
He's on probation before me?
Says he's got a bench warrant already. So.
He's got
Pretrial.
a pretrial before me.
Yes, Your Honor, I'm seeing a pretrial.
Yeah, I don't know
before
why
you.
it says
Yeah.
what it says here.
Yes.
I'm seeing a pretrial before you on Monday for B and E for illegal entry, and I'm seeing another one out of 55th. That's a retail fraud.
Got it. Okay, sounds good. Okay, so you understand that in order to give up all of these rights, you would first have to understand your right to the presumption that you're innocent. So you're innocent until proven guilty. You understand that? You want to waive your right to be presumed innocent until proven guilty? That means you're giving up your right to a jury trial, your right to remain silent at trial and not have silence be used against you, your right to require that the prosecution establish beyond a reasonable doubt each element of the charge being brought against you, your right to question any witness they call to testify against you, and your right to see them in court, and your right to subpoena witnesses to testify on your behalf. You understand all of those rights? Anyone coercing you to plead guilty? Any promises if you plead guilty? You're on probation, you're not on parole, correct? And you have other court date or criminal matters pending, correct? You understand that by pleading guilty, it could result in or have impact on your probation status. It also could have impact on your employment. You may need to report this to your employer or to a future job application. You understand that? It also could affect your ability to travel to different countries. So you might want to go on vacation somewhere, they could deny you permission into their country because of these convictions. You understand that? Okay. As to the attempted police or attempted resist and obstruct, how do you plead? Is that because you believe you are guilty? Tell me what you did to make you guilty of an attempted resist and obstruct. Okay, and when was this? Was it September 15th? Because today is September 5th.
I'm sorry.
August 15th? Okay, where was this located?
Don't put the address.
Does Lenawee Street in Capitol sound familiar at all?
Yes.
Okay, is that in the city of Lansing, state of Michigan, Ingham County?
Yes.
Okay, and why were you having contact with the police?
We just walked up to.
You was just sitting there over in that area and they just walked up to you?
Yes.
What were you doing in that area?
Just there.
It was just there? There for what purpose? What is that? What is that area?
Nothing.
What do you mean nothing? Is it a business? Is it a park? Okay, so you were at the park and you were just hanging out.
Yes.
Okay, were you by yourself?
I was with a friend
You was with a friend hanging out. Were you sitting on the bench, standing? What were you doing?
standing.
Okay, and then police officers arrived?
Yes.
Okay, and did you have any clue why they were arriving?
No.
Okay, and so when the police officers arrived, what did you do?
I walked away.
You started to walk away? And then they gave you a lawful command to stop?
Yes.
Or what you believe was a lawful command to stop?
Yes.
Okay, and you did it?
Yes.
Okay. Any additional matter or factual basis that is?
No, I think that's sufficient.
Nothing for the defense.
The court satisfied with the factual basis, I'll accept your plea if I get plea to be freely, voluntarily, and intelligently made. The matter is scheduled for sentencing October 31st at 9 a.m. When you leave here today, you go down one floor to check in with our probation department. They're gonna prepare a pre-sentence report about how you should be sentenced or how they believe you should be sentenced. And compile some information about what's going on with you in all these cases, okay? Do you have any questions at this time? Any additional matters for the record, counsel?
Nothing for the defense.
Nothing. from the-
Thank you, you're all set. One thing I noticed on my docket today is I had 6 police officer results. On the record in the matter of the state of Michigan versus Sergio Archer, 25-01873, appearance, please.
Thank you, Your Honor. Cassidy Chicas for people.
Morning, Your Honor. Attorney Derek Kristen, also public defender, on behalf of Mr. Sergio, who is in the building in city lockup. I've already met with him to discuss this case, Your Honor, and I'd wait his presence being here.
Thank you. Today was the date scheduled for a preliminary examination for Mr. Archer. My understanding is that the necessary witnesses have failed to appear, correct?
Yes, Your Honor, that is my understanding as well. I've not located them here in this courtroom today. I have not had contact with them. So I would expect more from the defense to dismiss.
Your Honor, at this time, we'd ask court to dismiss the matter. The prosecutor could bring the case forward again if the witnesses are willing to participate. I told Mr. Sergio he does have other pending matters, including with this court, so he will not be getting out of jail anyway.
Okay, we will get your dismissal in just a moment.
Thank you, Your Honor.
Thank you. The matter of the people of the state of Michigan versus Cammy Shaw, 25-02274. Is Shaw in jail? No. Jail, stick around here. Jail, Shaw's in jail. No, I don't have. Mr. Lee, I think this is your case. You have the remaining of my docket.
Sorry, yes, Cammy Shaw. I'm sorry, Your Honor, I have not seen her in the courtroom yet.
Have you had communication?
Yes. But it has been probably a few days since the last time her and I spoke.
Okay, let's see here. I have been trying to cross to adjourn. She had something going on at 55th, then she's not here. Okay, well, how is your bench warrant?
So the court is aware, Your Honor, we are seeking to likely move this case to mental health court as well in 55th. And
You're likely to do what?
we are likely to be seeking to move this case to mental health court for in 55th District Court for a plea. So that she would be remaining there, but I believe we need to find a way to do that, and we're still working on.
I'm not following. You're moving it for, I'm sorry, what are you attempting to do?
I'm not today. I'm giving the courts a heads up that whenever she reappears, we will be seeking to probably move this to mental health court in 55th
okay.
District Court.
Okay, so she's gotta be screened to see if she's eligible for mental health.
And I believe she has been screened and found eligible. We're just waiting on the forms.
Right, I do see that she was being held in 55th, at least in the first appearance in this court. So just a referral to mental health.
She was released. She made contact with pretrial services. I'm not sure why she's not today.
Okay, sounds good. For Archer, I'll give that to his attorney.
Oh, thank you.
A copy of it that is on the record in the matter of the state of Michigan versus Kristen, 25-02497. Appearance, please.
Thank you, Your Honor. Cassidy Chicas for the people.
Assistant Public Defender John Lee on behalf of Christopher King.
King has a carrying concealed weapon, assault with a deadly weapon, and assault and battery scheduled for examination today. How are we proceeding?
Yes, Your Honor. People have not seen the necessary lay witnesses for the assault charges on this case and would expect a motion from the defense on that. However, it's my understanding that the defense intends to waive the right to preliminary exam on the CCW charge.
That is accurate, Your Honor.
Assault and battery and the assault with a deadly weapon is what you're looking to do today. Sorry, it was Elise Greer. There's two. Who's the assault and battery on? Was Jordan Hewlett subpoenaed to be here today? Because that's a misdemeanor.
We verify. Yes, Jordan Hewlett was. Thank you.
Okay, he wants to waive the CCW.
That is right. Yes.
You understand your right to have a preliminary examination on carrying concealed weapons charge? You understand the purpose You have the right to require that the prosecutor establish that they have sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the person who committed the felony. You understand that? Counsel, can you grab this for me? You wish to unconditionally waive your exam, correct? Anyone threatening you to do that?
No, ma'am.
Did anybody promise you anything if you do it?
No, ma'am.
I find your waiver to be freely and voluntarily made. Your binder dated September 17th. That's the date the circuit court receives the file from the district court, not a court date for you, okay?
Yes, ma'am.
Your next court date in circuit court is going to be a pre-trial. And Mr. Lee will be the one made aware of that. Is your address still 913 West Holmes?
Yes, ma'am. Office 259. It's my business.
What's your home address?
1221 West Lenaway Street. I'm supposed to be moving. My family has to move because of the city. The city is tagging my home. We're supposed to be on by the 8th, and we've been in the process of trying to move. And not only trying to move because of the rent, or I mean the landlord that offered since last summer.
So you want your mail to go to your office?
Yes, ma'am, please.
Okay, and your phone number, sir?
I have two of them. It's 517-326-9838 and then 989-209-7413.
20974.
13. Both phones be with you.
Okay, if you have any additional changes, especially to your address, it's your responsibility to update the court and
Yes,
your
ma'am.
attorney, okay?
Yes, ma'am, respectfully. Thank you.
Okay, a bond was
I think-
originally set 25,000, 10%. That will continue. We'll just remove the GPS tether. And bond and the no contact order, it goes away because we don't have any victims here. Any additional matters for the record?
Not from Your Honor.
Nothing for the defense.
Thank you. You're all set.
I'm so excited.